and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by Livelaw. I'm your host Ostika Das and I'm here to take you through the most significant updates from this week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we are going to talk about Delhi Chief Minister Arvind Kejriwal's arrest, former Jharkhand Chief Minister Hemant Soren's plea against his arrest, plea seeking side effects of COVID vaccine to be examined, and much more. So let's dive into the headlines. This week, the Supreme Court bench of Justices Sanjeev Khanna and Dipankar Datta heard petitions from Delhi Chief Minister Arvind Kejriwal and former Jharkhand Chief Minister Hemant Soren challenging their arrests by the Enforcement Directorate. Kejriwal's plea related to the Delhi liquor policy case, if you remember, was argued by senior advocate Dr. Abhishek Manu Singhvi. Singhvi argued that Kejriwal's arrest was unjustified, pointing out that there was no evidence linking him to the alleged scam from August 2022 until his arrest. He questioned the timing of the arrest during the implementation of the Model Code of Conduct for the Lok Sabha elections without new evidence. Singhvi emphasized that Kejriwal had not filed a bail application but had submitted a writ petition contesting the arrest's legality. Singhvi highlighted discrepancies in the ED's treatment of its approvers, suggesting bias. He questioned the necessity of Kejriwal's arrest and emphasized the need for a fair examination of the case's merits. The bench posed queries to the Enforcement Directorate, particularly regarding the timing of Kejriwal's arrest, and asked the ED's counsel to come prepared with the answers on the next hearing day, which is this coming Friday. In Soren's case, the bench issued notice on his petition challenging his arrest in connection with an alleged land scam in Jharkhand. Soren's counsel, senior advocate Kapil Sibal, argued that there was no evidence implicating Soren and sought interim bail. The bench posted the matter for the week commencing May 6th, allowing the Jharkhand High Court to pronounce judgment in the meantime. Later in the week, the Jharkhand High Court announced its verdict on the petition filed by former Jharkhand Chief Minister Hemant Soren, challenging his arrest by the Enforcement Directorate in this alleged land scam. The bench, comprising Acting Chief Justice Sri Chandrasekhar and Justice Navneet Kumar, dismissed Soren's plea in a major setback to the former Chief Minister. He's been in custody since January, facing money laundering charges related to illegal mining and the alleged land scam. This week, a lawyer filed a plea in the Supreme Court requesting the formation of a medical expert panel to assess the side effects and risks associated with the Covishield vaccine. The plea follows admissions by AstraZeneca, the manufacturer of Covishield, regarding rare side effects such as low platelet count and blood clot formation. Covishield, produced by the Serum Institute of India, has seen widespread use in the country, with over 175 crore doses administered. The plea highlights an increase in deaths attributed to heart attacks and sudden collapse post-vaccination. It underscores that vaccines were administered based on government assurances of safety. The plea seeks compensation for those severely disabled by the vaccine and urges the union government to prioritize addressing this matter. This week, the Supreme Court rejected a petition seeking to postpone the Chartered Accountant exams conducted by the Institute of Chartered Accountants of India due to overlapping dates with the Lok Sabha elections. The CA exams for intermediate and final levels are slated for 8th and 14th May respectively, while the Lok Sabha elections are scheduled to be held on, among other dates, 7th and 13th of May. Senior advocate Madhavi Devban, representing the petitioners, argued that students from remote areas might face difficulties reaching exam centers the day after voting. The bench, comprising Chief Justice D.Y. Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra, heard the case and dismissed the petition. They reasoned that postponing exams by a day after each phase of polling, as suggested, would impose severe hardships on numerous students, considering the large number of candidates, over 4.36 lakh, and the extensive exam centers, 591 nationwide. Additionally, the court acknowledged the ICAI's concerns that providing opt-out options would disadvantage students aiming to complete all papers in one attempt. This week, a Supreme Court bench comprising Justices B.R. Gawai and Sandeep Mehta heard an SLP filed by editor Prabir Purkayastha against a Delhi High Court decision upholding his arrest by the Delhi police. Purkayastha's co-accused Amit Chakrabarti initially approached the top court but withdrew his plea after becoming an approver for the Enforcement Directorate. During the hearing, senior advocate Kapil Sibal, representing Purkayastha, revealed that his client was arrested on the evening of October 3, 2023 and presented before the magistrate the following morning at 6 am without his own lawyer being informed. Despite objections, the remand order was recorded as passed at 6 am, which raised concerns. The Additional Solicitor General, however, claimed that the early presentation was for a search and that the trial judge had mistakenly recorded the time of the remand order. However, the bench remained unconvinced, stating that subsequent remand orders with respect to the NewsClick editor would also lose their basis if the initial one was found nullified. After deliberations, the bench reserved judgment on Purkayastha's petition challenging his arrest and remand under the UAPA. This week, the Supreme Court mandated a minimum one-third women's reservation in the Supreme Court Bar Association posts, including in the upcoming elections. Justices Surya Kant and K.V. Vishwanathan directed one office bearer post to be exclusively reserved for women on a rotational basis, starting with the 2024-25 elections. This reservation does not prevent eligible women from contesting other posts. Additionally, the court mandated a one-third reservation for women in both the junior and senior executive committees of the SCBA. Elections for the 2024-25 term are scheduled for 16th May, with vote counting on 18th May and result declaration on 19th May. The court emphasized the need for timely reforms in SCBA norms, noting failed reform resolutions. In response, however, the SCBA convened an emergent general meeting to address the Supreme Court's directive. The meeting aims to discuss the national impact of the judicial amendment to Bar Association rules and decide on further actions. The SCBA Executive Committee, in a resolution, questioned the necessity of the court's order, stating that it had encroached on bar independence. The meeting, scheduled under Rule 22 of SCBA rules, will deliberate on the implications of the judicial intervention in Bar Association rules and plan future steps. This week, the Supreme Court's Constitution Bench reserved judgment on whether private resources are considered part of the material resource of the community under Article 39B of the Constitution. After 5 days of arguments, the bench, headed by Chief Justice D.Y. Chandrachud and comprising 8 other justices, concluded the hearing. Article 39B is a directive principle stating that government policies should ensure fair sharing of community resources for the common good. The key issue is whether privately owned resources fall under this provision. Appellants argued that material resources should encompass any wealth-generating resource benefiting society. They contended that if privately owned resources were intended to be included, the drafters would have explicitly stated so. In turn, the union argued for an interpretation aligning with evolving constitutional principles, emphasizing community wealth derived from individual economic activities. They asserted that resource in Article 39B refers to the collective economic foundation of a community. This week, the Supreme Court Registrar declined to accept the Union government's application seeking clarification of the 2012 judgment in the 2G spectrum case. In that verdict, the court had invalidated the first-come, first-served basis for spectrum allocation and mandated public auctions as the preferred method. Now, a decade later, the government sought permission for administrative allocation of spectrum in cases involving public interest or technical and economic reasons. Arguing that competitive auctions may not always be suitable, the Ministry of Communications had filed the application for clarification. However, the registrar deemed it misconceived, stating that it appeared to seek a review of the judgment under the guise of clarification. According to Supreme Court rules, the registrar can reject petitions lacking reasonable cause or containing frivolous or scandalous content. Additionally, the registrar cited the application's nearly 12-year delay. Under Order 15, Rule 5 of the Supreme Court Rules of 2013, the Centre has the option to appeal the registrar's decision directly to the court. This week, the Supreme Court, through a bench of Chief Justice of India D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, issued notice in a writ petition concerning the application of Shariat law to individuals who were born Muslim but no longer identify with the religion. The petitioner, a woman from Kerala and president of an organization of ex-Muslims, argued for her right to be governed by the Indian Succession Act instead of Muslim personal law for inheritance, given her non-believer status. Advocate Prashant Padmanabhan emphasized the complexities arising from personal law, where her father, also a non-believer, couldn't pass more than 1/3 of the property to her, with the remaining share supposed to be passed to her brother, who had Down syndrome. Initially cautious due to legal intricacies, the bench questioned the feasibility of the requested declaration under the Shariat Act and its conflict with the Indian Succession Act, particularly with respect to its applicability to Muslims. Nonetheless, after thorough consideration, the bench issued notice to the Union of India and the state of Kerala. The case is set for further discussion in the second week of July. This week, the Delhi High Court dismissed a plea aiming to disqualify Prime Minister Narendra Modi from contesting elections for 6 years. The plea alleged that PM Modi sought votes for the Bharatiya Janata Party by invoking Hindu and Sikh deities and places of worship. Filed by a lawyer, the petition cited PM Modi's statements about constructing the Ram Temple, developing the Kartarpur Sahib corridor, and retrieving copies of Guru Granth Sahib from Afghanistan. The petitioner urged the Election Commission of India to take immediate action. However, Justice Sachin Datta of the Delhi High Court deemed the petition misconceived, stating that it presupposed a violation of the Code of Conduct. The court clarified that it couldn't direct the ECI's stance on any complaint. The Election Commission of India assured that it would address the petitioner's complaint within the bounds of the law. This week, the Allahabad High Court refused bail to Uttar Pradesh Member of Legislative Assembly Abbas Ansari in a case where allegations were made that his wife had been visiting him in jail and he used a mobile phone to threaten witnesses and officials linked to the prosecution. Ansari, representing Mao Assembly, faced charges under various sections of the IPC, Prevention of Corruption Act and the Prisons Act. It was claimed that his wife visited the jail without following formalities and restrictions, and Ansari allegedly received special treatment from jail officials in exchange for cash and other benefits. Allegations also suggested a plan to escape jail with his wife's driver and certain officials' help. Ansari contends that no charges were directly against him, as the main accusations were against his wife and another co-accused who were already granted bail. However, Justice Jaspreet Singh's bench opined that considering Ansari's background and family history, the allegations against him might hold some merit, leading to the rejection of his bail plea. This week, a Delhi court dismissed former Deputy Chief Minister of Delhi and Aam Aadmi Party leader Manish Sisodia's second regular bail pleas in the money laundering and corruption cases linked to the alleged Delhi liquor policy scam. Sisodia remains in judicial custody in both cases. Special Judge Kaveri Baweja of Rouse Avenue Courts denied bail this week after having reserved the verdict earlier this month. Sisodia's previous bail attempts were also unsuccessful, with denials from the trial court, Delhi High Court and finally the Supreme Court, which also dismissed his review and curative petitions. The cases involve allegations by the CBI of Sisodia influencing decisions on the 2021-22 excise policy to benefit certain licensees without proper approval. The Enforcement Directorate accuses Sisodia of conspiracy to provide undue profits to specific companies through the excise policy. In a subsequent development, the Delhi High Court this week issued notice on Sisodia's bail pleas in the same cases. The single bench of Justice Swarnakanta Sharma directed notices to the ED and CBI. Sisodia's counsel, Senior Advocate Dayan Krishnan, requested continuation of the trial court's order allowing him to visit his ailing wife weekly, a request not opposed by the Enforcement Directorate. And that's a wrap for this week's Legal News Roundup. Before we bid adieu, the entire LiveLaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-visual format, we rely on your support. So here's the Fantastic 6 for you. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates and colleagues to spread the knowledge. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below. We love hearing from you. Don't forget to tap that bell icon to stay updated with our latest releases. And lastly, make a quick visit to our website at www.livelaw.in for our in-depth reports and analysis. I'm your host, Ostika Das, and it's been a pleasure bringing you this week's legal updates. Until next time, stay informed, stay engaged, and stay tuned to LiveLaw. Thank you for watching.